Crimson Trace announces Laser Guard Pro for today's most popular concealed carry firearms, combining a red or green laser sight with 150 lumen light, taking personal defense to the next level. Available now at your local dealer.
Today on Tom Gresham's Gun Talk, broadcasting from the 31st Annual Gun Rights Policy Conference, Tom talks with the people who are tirelessly working to protect our Second Amendment freedoms, including the attorneys who argued the Heller and McDonald cases, local and state gun right groups, and more. Now, here's Tom.
All righty, it is Gun Talk, and I'm Tom Gresham. We are at the Gun Rights Policy Conference. We're in Tampa, Florida. The Gun Rights Policy Conference, GRPC as it's known, gathers together the top movers and shakers in the gun rights world once a year to get together to share information, sometimes it's just to pump each other's tires up, because sometimes this can be a lonely business out there fighting the fight, whether you're working on a local level, a state level, or the national level, and you find out, oh yeah, other people have the same kind of challenges that we do. How did you guys do that? Oh, okay, that's a good idea. Here's how we were doing this. And also we'll be talking about, frankly, the outlook. And some are optimistic, some are gloom and doom with their attitudes. We'll get a little bit of all of that today. It's going to be very interesting. We're going to get into the weeds a little bit, because we're going to be talking about the whole idea of gun rights from the legislative side, from the litigation lawsuit side, from the political side, and we'll even talk about the election a little bit. It's going to be a fun time. We have a host of guests lined up. In fact, we've got two of the top dogs right here. Joining me right now is Alan Gottlieb, obviously the founder, the head guy at the Second Amendment Foundation and the Citizens Committee for the Right to Keep Bear Arms. Hi, Alan.
Hey, Tom, it's good to see you face-to-face rather than being on the long line.
That's right. Usually we're doing this thing, and you're on the telephone with us, so there you go. And we have also Don Kilmer, who's an attorney, a California-based attorney, Don, out in La La Land, and trying to take care of all of us out there. How are you?
I'm doing well.
Yeah, well, I'm glad that you are here. So, Alan, if you would, maybe you can kind of give us where are we? Because there's just been so much going on. We've got, obviously, the election coming up, which that's a whole different issue, really. But what's SAF been doing, particularly, what do you say, winning gun rights back, one lawsuit at a time?
Yeah, winning gun rights, one lawsuit at a time, and that's what we really do. We've got about 30 active cases going on right now.
Right.
And of course, Don Kilmer here does a lot of them in California.
Right. I'm trying to get your mic working there, Alan, and I'm not. Hey, let me see. Let's see what we're doing here. Here, let me troubleshoot just a little bit here, guys. We're going to see what we're doing here. Okay. Try that again, Alan.
Okay. Can you hear me now?
That's better. Much better.
Yeah, well, we're engaged in about 30 lawsuits nationally now. Of course, Don Kilmer sitting here does a lot of our legal work, or most of it, in California.
Right.
And so that's what we're most known for, winning gun rights one lawsuit at a time. Of course, this last month or so has been very heavily dedicated to promoting and putting on this gun rights policy conference, which is what we sponsor.
Sure.
Some of our other projects that people fly under the radar is our urban initiative project, getting into the inner cities, working with minority groups, and pushing gun rights in the inner cities. We're having some really great successes.
Now, are you staying under the radar on purpose on that?
Yeah, I guess we are doing it on purpose. A lot of people in the black community, where violent crime is running rampant in a lot of inner cities,
sure,
realizing that they would like to protect themselves and their family, but the local laws, usually New York, Chicago,
makes it hard for them
Baltimore,
to defend themselves.
Makes it hard. And we're picking up a lot of people that we're training so that they can stay on the ground as gun rights activists in inner city communities. And so when we leave a gun rights movement behind, and that's been really fun.
That's very interesting. It's it kind of goes to, and we talked about this. Let me get a little bit more there. We talked about this before, Don, about the whole. Sometimes you have to be looking pretty far ahead. Sometimes you have to be looking way ahead. And it's not the case you're working on right now, but it's the case that you are trying to get to. Does that make sense?
Well, there's several kinds of strategic litigation where you're trying to lay the groundwork for future litigation, and then there's also the idea of strategic litigation where you're trying to not just promote the individual right to keep and bear arms, which we all endorse,
right?
But for instance, one thing that SAF is very forward-looking on in sponsoring litigation is if we lose the right to engage in the commerce of firearms, then we're undermining the next generation's ability to buy weapons or buy ammunition. SAF was extremely helpful in the gun show case almost a decade ago, but right now they're sponsoring a case that's being kind of watched nationwide, which is Tixeria versus Alameda County. This was a case where 3 men wanted to open a gun store in unincorporated Alameda County,
right?
But Alameda County had a zoning rule that said a gun store could not be located within 500 feet of, and then there was this horror list of every other possible business structure. I might not be exaggerating. They couldn't be within 500 feet of a fire hydrant or something, but it was
it was whatever they could think of to keep a gun store out.
Well, it's actually classic redlining, which was actually done back in the 30s, 40s, 50s, and 60s as African Americans started joining the American economy and moving into the suburbs and trying to get jobs
it's always been used to keep those people out, whoever those people were at the time, right?
Yeah, it's a form of NIMBY, or not in my backyard.
Sure.
Okay.
No, exactly right.
And so the clients actually, all on their own, managed to get all the permits required. They got the fire chief signed off on the building, and the sheriff signed off on the building. They took care of parking. They hired an architect to make sure the building was secure. They were going to install security measures. They complied with everything the county wanted, except that the particular site was within 497 feet of a residential zoned piece of property.
497 feet.
Right. The rule was that it had to be 500 feet away.
Okay, so we are 3 feet off.
Yeah. It was it might have been 3 feet, might have been 30 feet, so I might be misremembering those facts. But it was
something like that.
Something ridiculous.
Right.
In addition to that, the property was across 8 lanes of the 880 freeway.
Okay, so no children were going to be walking across this 8-lane freeway.
No.
As if that was a problem in the first place.
Well, surprise, surprise, the Citizen Zoning Board actually approved the gun store and said, these guys are selling a lawful product. The 500-foot rule doesn't seem applicable here because there's a physical barrier, a freeway between them and the closest store.
Right.
So let's grant them the variance. Well, the Board of Supervisors reversed that decision, and that's what we're in court for. We lost in the district court, but we won 2-1 in the Ninth Circuit Court of Appeals. The county has now asked for en banc review. En banc review is when an appellate court, when the entire court sits instead of just a 3-judge panel. And so we filed our brief opposing en banc review, which is a new position for me, by the way, where I'm the winner and I'm trying to say, uphold the win. And we filed that brief on Tuesday.
Okay. Well, to your point, Alan, I'm thinking if you don't protect the ability to have commerce in guns, people say, well, we'll always have the Second Amendment. I say, well, you'll always have the words, but if you can't do anything with the words of the Second Amendment, if you can't buy a gun, transfer a gun, own a gun, shoot a gun, then, yeah, there's a piece of paper out there, but you really don't have a Second Amendment.
Yeah, that's obviously correct, and that's why some of this legislation or litigation we get involved in is really what I call cutting edge, and we're not looking at where the battle even is today, but we're looking at where it might be tomorrow or where your rights will be tomorrow. So we try to take a forward view and lay things out now strategically that would allow us to make sure our rights are maintained in the future. And so a lot of people don't feel, like the average gunner doesn't feel threatened by litigation that we're engaged in California, Don just talked about, because it doesn't affect them directly,
right?
Except it really does, and it affects their children and their grandchildren in the future.
Right.
So that's why this litigation is so important.
All right, hold that thought here. I'm going to take a quick break here. We'll come back. Let's talk a little bit about that. Tom Gresham, we're at the Gun Rights Policy Conference in Tampa, Florida, and we'll be right back.
Want to customize the look of your firearm and give it ultimate durability? Well, don't paint it, Cerakote it. Cerakote is a spray-on ceramic polymer coating that uses state-of-the-art technology to achieve superior abrasion resistance and corrosion protection. Field-proven and trusted by manufacturers and gun owners like you, Cerakote is the industry's unmatched performance leader. In lab testing and real-world applications, Cerakote outperforms the competition every time. See for yourself and find a local certified applicator near you at Cerakote.com. Choose the best. Choose Cerakote and finish strong.
You got your carry permit, and that's good. But you know you could use more training. Get the DVDs, which have what you need. Springfield Armory presents Concealed Carry 1 and Concealed Carry 2 with Bata Group. Learn specific concealed carry skills from Top Gun fighting trainers. Get trained. Be prepared. This really is life and death. ShopGunTalk.com. That's ShopGunTalk.com.
The Ruger American Rimfire Rifle combines features of the Ruger American Rifle and innovations of the 1022 Rimfire Rifle to appeal to all bolt-action enthusiasts. It features a modular stock system that provides comb height options for scope or iron sight use, a power bedding integral bedding block system for outstanding accuracy, a Ruger Marksman adjustable trigger, and a 1022 style rotary magazine for reliable feeding. The Ruger American Rimfire Rifle, another rugged, reliable firearm from Ruger.
If you're looking for a safe and trusted way to sell your firearms, look no further than Dury's Gun Shop. I trusted them to sell my dad's collection. They built their business for over 50 years on honesty and customer service. Dury's Guns will buy any size collection or estate, none too big or too small. Selling your firearms to Dury's Guns is easy. Go with the pros. I trust Dury's Guns. DurysGuns.com.
Are you looking for a place to shoot? The National Shooting Sports Foundation has a great website called wheretoshoot.org. It's the largest database of shooting ranges on the internet. It's also a great resource for shooters where you can find video tips, printable targets, and a lot more. Find it online at wheretoshoot.org. And while you're there, download their free iPhone app. That's wheretoshoot.org.
All right, we're back with you. Tom Gresham at the Gun Rights Policy Conference in Tampa, Florida, sitting here with Alan Gottlieb and with Don Kilmer. Don, you said you wanted to expand upon this case because it's an important one.
Yeah, the Teixeira decision out of the Ninth Circuit, when the county filed its en banc review, first of all, they hired one of the best appellate law firms in the country. Mm-hmm. So that's kind of an indication of how important at least the anti-gunners are treating this case. The county is spending real money, not just letting their county council litigate this case anymore. But, for instance, the county in its brief, one of the reasons they cited for why this should be reversed and that we should be allowed to redline gun stores and not allow them into certain neighborhoods was they pointed to at least 10 or 15 other California cities or counties who have this exact similar rule, mm-hmm. and they're claiming that they're not really an outlier. Well, we kind of had to point out that, that's kind of the point of the lawsuit, is that this is wrong everywhere it's tried.
Right. Just because a lot of you are doing it doesn't make it right.
Yeah, we just picked on you because these were where our clients were.
Yeah, you've got the golden ticket on this one, so there you go.
Well, Alameda County also has a history of being knee-jerk anti-gun.
Is there an argument to be made? I know that everybody talks about, California is such a problem for gun rights, and it is. But at the same time, it also does not give you an opportunity to work on things that are going to be coming on to the rest of the country, where you can identify a problem there and attack it there.
It does, Tom, but here's the problem we have. California being as left of center as it is and as anti-gun as it is politically,
right,
that ends up becoming to the courts as well, because the appointments are anti-gun left-wing political judges at the same time.
So it's also harder to get decisions.
So it's harder to get the decisions we need because you don't have rule by law, you have rule by man, and what I call it. Yeah. And as a result, you're looking at to lay it out a little bit better. If you look at where we have problems legislatively and bad laws, you look at places like Massachusetts, Connecticut, New York, New Jersey, Maryland, California. Mm-hmm. Those are also places where we also have, unfortunately, the worst judges sitting on the bench. Mm. In both federal and state courts. And so the problem is it makes it harder for us to get the remedies we need because the deck is stacked a bit against us.
Sure.
That's why this upcoming election is so important, because the few doors we still have open to us are going to get slammed in our face.
And it's not just the Supreme Court; it's the lower judges too,
Right,
because that's where very few cases actually make it to the Supreme Court.
Right. So that's why this election is so important to us. If Hillary Clinton gets the White House and gets to name the judges, our whole litigation strategy is going to have to be probably put on hold. That's why I'm saying the 3 words every gun owner should be thinking and saying over and over again between now and November is ready, aim, vote.
ABC, anybody but Clinton.
Well, the paradox, though, although the gun laws are horrible in California and getting worse, sales couldn't be better.
Isn't that interesting?
The California Department of Justice keeps track of the number of background checks they do for gun sales. And, of course, in California, we have a rule that says no gun can be transferred to anybody. I mean, the only exception are literally family members, a father to a grandfather, or a father to son,
yeah.
Mother to daughter. Those transactions don't have to go through a dealer, although you can voluntarily notify the government of that. They even have a rule that siblings can't transfer guns between themselves without going through a dealer.
So they have a record of everything that's moving, basically, for the most part.
Exactly. And California's the background checks for transfer of firearms has been knocking on and even touching 1 million a year for about the past 5 years. And it doesn't look like it's going to slow down at all. Of course, if the legislature has its way, we're all going to be buying and selling cowboy action shooting guns because they won't let us have semi-automatic rifles. But the point is that there is still a strong gun culture in California, but they're just so beat down by the legislature. But California has always had a history of being a kind of a schizophrenic state. There's red California, and it's deep red.
Right.
Okay.
Right.
And then there's blue California, and it's deep blue.
Interesting. Well, there's
a fault line that runs through California.
Yes.
And that's why you have all these earthquakes.
Yeah, it's a political fault line. Exactly. And it does give you these interesting cases. You have... What's going on with the roster out there, the handgun roster?
That case has been briefed, and we're waiting for oral argument on it. I think there's a couple of cases that are dealing with commerce and firearms that are ahead of it, and I think if we go down the paranoid path of that these cases are being managed behind the scenes, which I don't endorse, but it would make sense that the roster case is going to be second behind. For instance, Tixeria and the 10-day waiting period case that we also won last year.
You're right, the 10-day waiting period case that we went to in California.
But now it's going back to en banc, or what's going on there?
No, the 10-day wait period case. Should I give a little context here?
Yes. Yeah, real short.
Yeah, California required a 10-day waiting period, even if you had a concealed carry permit and you had a gun full of safes or a safe full of guns.
Which made no sense. You already are okay to your own gun, so why should you have to wait to get another gun when you already have a gun?
And we had to have a 3-day trial to prove through the government's own witnesses that the background check literally takes about 3 minutes.
Aha.
Yeah, California has state-of-the-art computers. They run your name using your driver's license through about 10 or 15 different databases to make sure that there are no active warrants against you, there's no domestic violence restraining orders, that there's no warrant for you in another state,
right?
That you're not even sought for questioning in a case, you're not on probation, anything like that. And that literally takes, the government's witness testified that in most instances it takes like 30 seconds.
Wow.
Yeah, these are the kind of cases staff gets involved in.
Right.
And so, I mean, we're like all over the map on these. Then we just won 2 very big important ones. Binder up in Suarez at an en banc panel in the 3rd Circuit. I got the right circuit? I think
those are Alan's cases. I'll let him talk about those.
We'll let Alan Gura talk more about those.
Okay.
But these are really, really important. They're sort of restoration cases where people committed nonviolent minor felonies many years ago, but under federal law, they won't, even though the state of Pennsylvania in this case restore their rights, the federal government won't recognize that. And so we won it on an en banc panel, and it's really an important case because, as you know, the anti-gunners try to disenfranchise as many people as possible from gun ownership any way they can.
Right.
Through the VA, through other means. And this is a way of getting lots of people's rights back, and it opened a big crack in the door for a lot more litigation to be filed all over the country.
How are you coming on getting Martha Stewart on the SAF board, by the way?
Yeah, like Martha Stewart, why should she be banned from owning a gun to protect herself?
Yeah, but she is, actually.
But she actually is. And so this opens up, a big area for us in litigation. And this is a case that's probably definitely going to go to the Supreme Court, in my opinion. At this point, we really believe the government, the federal government, is going to appeal it. Since it was already heard in Bonk, and we won it in Bonk, which is unusual for us. We usually win at the appeals court level if we're lucky, and then get overturned in Bonk. At this point, we won it there. The government's probably going to appeal to the Supreme Court, and it's interesting because in this case we got a couple of Democrat-appointed judges who normally don't vote gun rights on the court. They don't vote our way, so to speak. Came across to give us our victory.
Really?
So there's a really good chance we're going to splinter the U.S. Supreme Court. Some of the Democrats there may end up going our way, and it could be the third major win at the U.S. Supreme Court.
Well, that's pretty interesting.
Well, there's also a body of law that says that you have to look at the right to vote, the right to hold public office, the right to sit on a jury in the same way you look at the right to keep and bear arms. The idea would be that when a felony conviction disenfranchises you of all those rights,
right,
and the restoration cases prior to this said you had to have all the rights restored or none of the for instance, there are states that restore your right to vote after you're done serving your sentence. But because only your right to vote was restored, your right to keep and bear arms isn't. So
under the federal government's interpretation of law.
Right. The federal government tries to say it's an all or nothing proposition. You have to get all the rights back or none of the rights back. It's a extremely cramped or stingy view of rights. Every other fundamental right that we look at has been broadly interpreted.
And that's one of the points I wanted to point out, is that what you're really talking about is rights. Guns, of course, are part of that, but it's really a rights issue. And in the 30 seconds or so we have left, Alan, if you would kind of just give us a synopsis, what's your sense of where we are?
Well, I really think we've obviously over the last few years, I believe we've gained ground. But, I always tell everybody this is like a football game where the rules have been changed. It doesn't matter how many points we score. If the other side scores one touchdown, we lose our rights. We have to win every case, or we, and that's a standard that's very hard to meet.
Yeah.
But we try really hard.
Yeah, it is. Don, look, I got to get you back on because we got so much more we need to talk about. We're just running out of time. Okay,
Sure.
We'll get you set up. We'll do it by phone. We'll do the whole deal.
No worries.
All right. And Alan, thank you so much. I know you got to run out and basically run the Gun Rights Policy Conference. I stole you from the floor, and it was on time when you left. You better be on time when you get back there. All right.
I hope so.
All righty. All right. Don't go far. When we come back, we'll have more right here at the Gun Rights Policy Conference in Tampa, Florida. I'm Tom Gresham, and this is Gun Talk.
Welcome back to Tom Gresham's Gun Talk. Now we rejoin Tom at the 31st Annual Gun Rights Policy Conference.
All righty, we're back. Tom Gresham here. We're at the Gun Rights Policy Conference in Tampa, Florida, having some fun. We're doing hot swapping of folks. We got rid of our last guys. We had one lawyer on. Now we're going to up the game and go with two lawyers, which may not be survivable. I'm not really sure how this is going to work out. We got Alan Gura joins us as well as David Sigale. Hey, guys, how are you?
Good, Tom. How are you? Nice to be here.
Great.
Excellent. Okay, obviously you guys are two of the preeminent lawyers working on gun rights cases. David, you're in Chicago, right?
I'm based in Chicago, right outside Chicago, yeah.
Based in Chicago, and I know you're in the D.C. area, Arlington, but you guys do cases all over the country. You just, pretty much.
That's correct.
Yeah.
So, if you would, I know there's some cases, and I know that for listeners, they're going, well, boy, you're sure talking about a lot of these law cases, and it gets kind of complicated and all. But this is really where the action is taking place right now, because we're not getting a lot of legislation, at least not a lot that's helping us. Would you agree that a lot of the action right now is in the courts? Is that a fair assessment?
Yeah, I think that's true. I think that back in Illinois, there's a lot of maneuvering and whatnot taking place behind the scenes.
Right.
But in the sense of are there headline items, not at this moment, but
right.
But yes, I'd agree that a lot is happening in the court. At least that's where people seem to hear about.
So what are the interesting cases that people need to know about? Because I know you guys work several ahead. You think, okay, and people get frustrated with you. They say, well, why didn't you go for everything on this one? Well, sometimes you can't get everything. You have to just get what you can and work your way toward.
That's correct. There's not going to be a case that gets everything all at once. It's just not the way our system works. The fact is that judges can focus on only so much at a time. They can only bite off so much information at a time. We have word limits. We have limits on people's attention span. And the law builds step by step in little bits. And so we try to get those fundamental steps done first. And we look for opportunities where we can get a good result for someone and establish precedent that will then help us into the future. And some of those preliminary steps are actually quite large. We're very excited about some of the cases that are going on right now. Obviously, we're not winning every single case, and the situation in the courts leaves a lot to be desired. But there are times where a client will come to you as an attorney, and he has a problem not with future legislation, but with the legislation that's on the books today that's impacting his rights, and you need to deal with that. And I've been very happy that, at least in a few cases, we are making some very large strides.
Give me examples. What are you talking about? What are the ones that you're excited about?
Sure. Well, the one that is perhaps the most exciting at the moment, and which is, I think, going to have a lot of impact, is a case that we just won in the Third Circuit. The full Third Circuit Court of Appeals, en banc, affirmed two of our victories in Pennsylvania that we had established over the last couple of years in a case called Binderup versus Attorney General. Now, what's this about? In these cases, the federal courts have stopped the federal government from enforcing the so-called felon in possession ban against people whose crimes were deemed not serious and occurred a long time ago, and who are by no stretch of the imagination dangers to their community.
Okay.
As you know, the felon in possession ban is a very broad law. It impacts dangerous and seriously violent people who should have no guns at all, obviously, but it also grabs a lot of people with crimes that are not what you'd imagine to be.
Because there are a lot of crimes that are punishable by a year or more in jail that a lot of people would think, really, that's not that big a deal.
That's correct. And as the judge in our case pointed out, a number of these. For example, if you return a recycling bottle in Michigan to get your deposit back and the bottle came from out of state, that could be a felony, right?
What?
If you smoke a little pot in any amount, but you do it in the wrong state, let's suppose Arizona, our last three presidents would be completely barred from having guns. What if you take a few extra food stamps for your family because you can't feed them? What if you, in my cases that we won in the Third Circuit, what if you have an ancient conviction for corruption of a minor? Because somebody had maybe an inappropriate affair with someone who was old enough to consent, not a question of any sex offense.
Right.
But nonetheless, they went after him for misdemeanor corruption of minors. Or what if you have a case where somebody has a one-time DUI in 49 states and Washington, D.C., if you have a DUI, you don't lose your gun rights. You lose your driver's license for a short amount of time.
Right.
If your DUI is in Massachusetts, because the potential jail sentence is just a little bit over 2 years, the federal government will take away your gun rights forever.
For life, for a DUI.
For a DUI.
Holy cow.
And does that make sense? I have a case on that.
So what does this case do for us?
What this case does for us is the following. First of all, people who have non-serious crimes, non-violent crimes, crimes that are misdemeanors or non-violent felonies, people where you look at them and you say, gosh, this person should not be disarmed, they now can go to federal court and try to convince a judge to get their rights back. Congress used to have a process for this.
Right.
Senator Schumer got that defunded. He said, we don't want to give people their rights back. We'll pull the plug from ATF processing these claims. Well, now after Heller, it's a constitutional issue, and courts are listening to it, and they are giving relief. Hopefully, if we win enough of these cases, and I suspect that there's a good chance that we will continue to do so, maybe Congress can revisit this idea that this process is being defunded. In the immediate future, though, let me just warn or advise the listeners, I think there's a very good chance that this case goes to the Supreme Court. This is a loss for the federal government in the en banc full Court of Appeals. There is no other step other than to go to the Supreme Court. And they've stopped them from enforcing a federal gun law.
And
so
you think you've got a pretty good chance if it goes to the Supreme Court?
I think we have a good chance in the Supreme Court. It is by no means assured. We would not have won this case without getting at least a few votes from judges who are thought of as being liberal, let's just say. Okay? This is a great case because you don't have to like guns or gun rights. You can think Heller is wrong and stupid and evil and should be reversed. But now that it's a right, do people get their rights back? Is there an avenue for...
Is a life sentence on your rights?
That's correct. And so if we can speak in the language of rights generally, not so much talking about the Minutemen and Madison, that's not going to appeal to everyone.
Right.
But this is a right now. So do felons get their rights back? I mean, the left wants the right to vote restored for people. There are other rights that are impacted. So hopefully we can make this a package deal, and hopefully we can convince our friends on the other side that this is something that has a broader implication than just guns.
All right, hold that thought here. We'll take a quick break here. We're talking with Alan Gura and David Sigale, two attorneys, top attorneys on the Second Amendment. And I'm Tom Gresham, and this is Gun Talk.
Want your next gun purchase to be fast and hassle-free? Well, at galleryofguns.com, you can search through thousands of models from our huge firearms inventory. Find a great offer from a local dealer that includes all fees and taxes. And there's no need to arrange a transfer. Gallery of Guns takes a small deposit on your credit card, and your gun will be at your chosen dealer in as little as 48 hours. Plus, your gun will be covered by our guaranteed lifetime replacement warranty. Galleryofguns.com. Search, find, buy. It really is just that easy.
If you're a hardcore duck hunter, Mossberg has a gun for you. The new Pro Series shotguns were designed and built to be the most reliable, most durable semi-automatic duck guns anywhere. Rain, ice, snow, it doesn't matter. When the weather gets tough, these new Mossberg shotguns will keep the shot flying and the ducks falling. This season, don't leave anything to chance. Head to your blind with one of the new Pro Series shotguns from Mossberg. Great performance at a great price. Learn more at mossberg.com.
For 36 years, the U.S. Sportsmen's Alliance has been fighting to protect hunting, fishing, and trapping for sportsmen from coast to coast. Today, we are under constant attack from extremist animal rights groups who want to end your ability to hunt in the U.S. Join us to protect our sporting heritage and our way of life outdoors. To join or for more information on how you can help, go to ussportsman.org. That's ussportsman.org.
A great trigger can make you a better shooter. For over 60 years, Timney triggers have been trusted by hunters and shooters everywhere. Timney triggers are proudly made in the USA and come with a lifetime warranty. Installation is easy. Give yourself the Timney Trigger advantage. To see more and order online, go to timneytriggers.com. That's TIMNEY triggers.com.
All right, back with Tom Gresham here, Gun Talk from the Gun Rights Policy Conference in Tampa, Florida. Visiting with David Sigale and Alan Gura. Now, David, you're in Illinois, and you just argued a case there. The Culp case, is that what it is?
Yeah, it's called Culp versus Madigan. It was set for oral argument and on Thursday, a couple days ago, in the Seventh Circuit Court of Appeals. And, it's one of those things you never know. Of course, how cases are going to turn out, but from what I've heard, the vibe seems to be positive. So we'll keep our fingers crossed for that.
What was the issue?
Illinois, as a result of the Moore versus Madigan case, which Alan and I worked on together there in Chicago, as well with a third gentleman, Dave Jensen. Mm-hmm. Illinois, which was the last state to have a concealed carry law, was all but forced to pass one, and they did finally in July of 2013. Part of that one statute within the act, we'll call it, is the non-resident. And if you have a home in your home state, you're a non-resident, but in your home state you have a concealed carry license, you can apply for one in Illinois. If Illinois deems your state to be similar enough And if it does, then that state is approved for people to apply for a concealed carry license.
Deemed to be worthy.
Deemed to be worthy. And if you're one of those states, the 45 states, because only 4 were approved, Hawaii, New Mexico, Virginia, South Carolina. But if you don't live in one of those 4 states, you are not allowed to apply for a concealed carry license in Illinois. Okay. Doesn't matter how qualified you are. We have 9 individuals from 6 different states who are plaintiffs in the case. 3 of our 9 plaintiffs are certified Illinois concealed carry instructors.
Okay.
So they're allowed to. The state has deemed them worthy to use that lingo of being able to teach.
They can teach it, but they can't get their own permit.
Not only can't they get their own license, they can't fill out an application.
They can't even apply for it.
They can't even apply for it.
Okay.
One of our plaintiffs, Mr. Culp, is an Air Force colonel stationed in Illinois. Mm-hmm. One of our plaintiffs is a firearms manufacturer. One is a firearms trainer. That's his job.
Right.
And these people are not allowed to apply for a license. And we sued over that, and that's what we went to argument about. And what the district court did was, and I don't want to get too all legalese, but basically the district court judge, the lowest court trial level, when we moved for an injunction to strike down this law, said, well, okay, plaintiffs, you're right on everything, but the state says there could potentially be, someone might slip through the cracks, and so I'm going to side with them.
Yeah, you're right on the law, but I don't care.
And essentially, yeah, it's I don't want to.
I don't like the result. Is what it amounts to.
It's the.
Go ahead.
Sorry about that. It's the equivalent of the judge saying, "I don't want to be responsible for this."
Right.
If ever hypothetically something were to happen, I don't want to be the one responsible.
Right.
So it went up to the Seventh Circuit, and the argument was basically the state saying that, some hypothetical calamity could happen, and me arguing there's no evidence any calamity has ever happened.
It's never happened. They always worry about, well, what could happen? You go, well, we have all this history in all these other states, and it hasn't, so what makes you think it's going to happen here?
And on top of that, this isn't even a reciprocity clause that we're dealing with. These are people that just want to fill out an application.
Wow.
And if they fail on their own merits, if they don't,
but at least let them fill out the application.
Yeah, let them, give them an opportunity to show that they are, again, to use the word, worthy.
Okay.
So
you think that's now we wait.
Now we wait.
Okay. I mean that's what you do.
But it's one of those, it sounds like a small point, but to go back to something you guys were talking about before the last break, it's a case that has to, it's the next stepping stone that has to follow Heller, has to follow McDonald, has to follow Moore versus Madigan, because otherwise it's very much putting a cart before the horse.
Yeah.
And it affects the people in 45 states of the union. So while it's, some people would say, probably not your listeners, but some people would say, oh, it's, so what? So they can't get a concealed carry license in Illinois. What's the big deal? Well, I mean, it's a fundamental right, and it affects the people in 45 states. Yeah. That's a big deal.
Exactly. Alan, obviously you argued the Heller case, McDonald case in front of the Supreme Court. What I'd like to do, we're going to take a quick break when we come back. I'd like to get you to talk a little bit about kind of where we are with that, because how long has it been since Heller now?
Heller was 2008.
2008, so 8 years. Mm-hmm. Okay. So, the question is, and I just read a piece you wrote about this, is kind of where we are, how are the courts interpreting that? And the other thing is, everybody knows we're looking at a 4-4 split right now in the Supreme Court, and what does that mean? So I don't have time to get it in right now. We're going to have this hard break charging up on us, and we'll get to that. We're at the Gun Rights Policy Conference in Tampa, Florida. We've got, it's an incredible array of people. If you're not here, why aren't you here? Because this thing is free. You ought to be here. In fact, make plans next year. We'll have an announcement maybe by the end of the show on where it's going to be next year. And it's, like I say, it's kind of where you go to find out what's going on with everything in gun rights. We'll be right back. All right, back with you, Tom Gresham, at the Gun Rights Policy Conference. Alan Gura, started to ask you, obviously you argued the Heller case, argued the McDonald cases for the Supreme Court, law of the land, major cases, and yet on the lower courts these days it seems like some of them are kind of ignoring Heller. What's going on?
Well, that is a great summation of it. They're more than kind of ignoring it; they're completely ignoring it. I mean,
Really?
there are courts that read Heller and McDonald faithfully, and they wrestle with it and they try to apply it. And so, in those courts, I think we have a fair chance. But there are some judges who read Heller to mean just about squat, and it's become optional precedent in many courts. There are things that Heller expressly forbids courts to do, which courts are doing anyway. And this is not just me or other gun rights people saying so. There have been some very liberal, non-gun-oriented commentators who have written a series of law review articles about the fact that the Supreme Court is essentially out of business on this issue.
Really?
Oh, yeah. As long ago as 2012, there was a gentleman who was a former attorney for the Brady Center. Professor Alan Rostrom now teaches at the University of Missouri, Kansas City, who wrote a law review article that basically the thesis of it was that Justice Breyer's dissent has become the controlling opinion in Heller because everyone is engaging in this interest balancing exercise. I mean, if you remember back in Heller, there was this debate between the majority and the dissent as to whether or not, if you have a right to keep and bear arms, can the state basically then say, well, it's nice that you have the right, but our interests in regulation are so strong that we're going to balance out the difference.
But that was the losing opinion.
That's correct. And the majority expressly said, thou shalt not do this. This is not how we treat fundamental rights.
Right.
And yet we see courts engaging in this type of exercise. So a long time ago, in this, in the sense that this is a long time ago in 2012, already we were seeing the other side saying, look, you can still do balancing. Breyer was correct. More recently, there was another article which is making the rounds that said that as the Supreme Court is taking far fewer cases than it usually has, and this is a problem that has nothing to do so much with guns or Heller. It's just more of an institutional problem that the court has. Lower courts are beginning to narrow from below. They're beginning to correct the mistakes that the Supreme Court has made. It's an unbelievable position.
That's topsy-turvy.
Upside
down world.
That you can even describe it and say, yes, this is what's going on, and it's fine. Because, we need the lower courts to sort of put the Supreme Court back in the bottle. And of
course, then they can do that with the knowledge that it's unlikely that the case will actually get to the Supreme Court.
That's correct. The more the Supreme Court has declined to review decisions that snub their noses, the more encouraged and emboldened the lower courts are to do what they want. Because what are you going to do? File for a cert petition? Good luck.
Yeah,
and
right.
so we have the court not policing its docket, and so judges are essentially doing what they want. And for a right which is not universally loved in the lower courts, that is a problem.
It's not being protected by the lower courts.
Nope.
They're not honoring what the Supreme Court said. Is it true? I think I read somewhere that the Supreme Court takes like 3% of the cases that are appealed to it.
It's probably a lot less than that even.
Is it really?
Yes, and the docket has shrunk greatly. The court used to hear 120 plus cases in a term. Now it's down into the low 70s, maybe the 60s, and it's gotten worse, of course, now that there's a vacancy.
Sure.
So, and the rationale is the more closely divided they are, the less anyone wants to take a chance on anything.
Right.
So,
I understand. So, the likelihood of being able to get your case to the Supreme Court and say, well, we'll appeal that. Well, you can appeal all you want to, but it's unlikely you'll actually get
but I do believe we're getting there. It's, as with the Bindrup case I mentioned before the break, we are getting near the time where they will have to take the case. And we'll see what happens.
Hey, guys, thanks for stopping by. Alan Gura and David Sigale, top attorneys for the Second Amendment. We really appreciate that. All right, don't go far. We're going to be back in a minute with more Gun Talk.